Hi, welcome to All Things Divorce Podcast. I'm Launi Sheldon, the host of All Things Divorce Podcast. Today we have Greg Davis on our show, and we'll be talking about the intersection of family law and civil law, which this is really fascinating if you're going through a divorce and there's some other issues outstanding. So a little bit about Greg. Greg is a good friend of mine. He's a very well-respected attorney. He's one of those attorneys that actually cares about his clients and really wants to work hard for them. So I've had cases against Greg. I've worked with him on cases. Greg has been practicing in Arizona since 1992. For the lion's share of that time, he has worked for or concentrate on complex family law matters. And he has, that includes high conflict family law matters, custody matters, but also business valuations and complex business issues and financial issues. For the last several years, Greg has helped spearhead the collaborative divorce movement. He's a founding member of Davis, Blaze, Stone, and Holder. And after a year-long sabbatical, he is now practicing solo as Davis Limited. Just remember, the information provided here is for entertainment purposes only. Greg and I are licensed to practice law in Arizona, and listening to this podcast does not create an attorney-client relationship with either me or Greg. Again, Greg is a good friend of mine, and he's very well respected. And so this information that we're going to get from him is really interesting information. So Greg, again, we're talking about how cases near the intersection, and really the intersection, I think, of civil and family law. What does that look like, and what is that?
Well, let me back up 1 second, because it occurred to me as I'm listening to your disclaimer. If you're in the audience and you're listening and you're not from Arizona, obviously I'm only licensed in Arizona, so really I know only Arizona law. But that doesn't mean you can't listen, understand, and go to your lawyer from out of Arizona and have a talk with that lawyer about how the concepts we talk about here on All Things Divorce might apply to you, because they might. So civil and family, the intersection is really, it falls into one of two categories. It's either a tort or a contract. Tort is a civil wrong, like a personal injury or a slander or a libel or a breach of fiduciary duty, where one party owes the other an obligation to consider their interests financially, and not commit fraud, not lie about money, not hide money, that sort of thing. And then on the other side, there are contracts. So there are business relationships, which are governed by business documents, business agreements, and each of those has their own intersection with family law. Where torts are concerned, very often, especially in domestic violence cases, one spouse will have a claim against the other. And in Arizona, I have had a number of occasions where my clients have come into me as victims of domestic violence within the last 2 years, because 2 years is the statute of limitations in Arizona for personal injuries. And so I will often suggest to the client that we do two things: that we file the divorce to make sure their marriage is ended, and their children are protected and their assets are divided, but at the same time file a civil lawsuit for battery, because with battery you have an opportunity to get damages for your medical bills, damages for your pain and suffering, punitive damages, which are designed to punish the wrongdoer and others that are similarly situated from committing such conduct in the future. And I found that, especially in domestic violence cases, it's a very, very effective strategy to get the best outcome you can get.
Okay, and so let's kind of talk about that, because I know I had a case, and we had threatened to sue civilly, but had eventually waived that in the mediation. But one of them was, in this case, my client had, the other client had cheated, the other side had cheated, and gave her a sexually transmitted disease. So, I mean, one that didn't go away. So
the one that keeps on giving.
The one that keeps on giving, yes.
Yeah.
So would that be something that someone could sue for?
Absolutely. I've done that before. So there are a couple of things to watch out for. So on the one hand, it's certainly actionable under Arizona law. You can sue for negligent transmission of a sexually transmitted disease. That is completely recognized in Arizona, and is a valid cause of action. On the other hand, when you do that, you have to prove that that you actually didn't have a sexually transmitted disease before your partner gave it to you. And so I've had a female client who alleged that her husband transmitted herpes to her by cheating. And unfortunately, it also means that all of her gynecological records from since the beginning of her marriage and even before are fair game for discovery. And so the other side then has an absolute right to all of the plaintiff, or my client at the time's, records. That is, or can be, humiliating. Nobody wants that sort of thing. And so it was important for me to convey to my client, you have a good case here, but be prepared to show your records from the beginning of time. Having said that, there's another sexually transmitted disease, HPV, which is virtually ubiquitous now. I think the latest statistic is 80% of people who've had sexual intercourse at least once in their life carry this virus. And so if there's a history of HPV, or at least reference to it in prior gynecological or urological records, then the question's going to be, how much damage did you really suffer? And I can't tell you how many doors that opens that you probably don't want opened. And so those kinds of cases get nasty, and too many people who start them wish they never had. And so those are risky. But if you've been the victim of domestic violence, those cases are quite clear cut oftentimes. And one of the greatest things about filing a battery case along with the divorce is it's a huge incentive to settle, because very few lawyers practice both civil and family. Now, I happen to do that. And so my client has the advantage because my client only has to hire one lawyer. If necessary, I get to take two different depositions of the same person.
Oh, interesting.
And as we all know, it's not difficult to catch somebody in a contradiction under oath when you get to ask the questions twice. And so it's a huge strategic advantage if used properly. And it's less expensive for my client than it is for the other party on the other side, because they have to hire two lawyers and my client doesn't.
Somehow, hold on, I'm somehow going out of focus. Hold on, let's see if that, I'm not sure what's going on here.
Your finger's in focus, but
my finger's in focus, but my face is not in focus. I guess we'll just keep going. That's starting to get a little, there we go. It's a little more in focus now. That's interesting. Yep. Okay. So, and are these cases tried together, or are they tried separately? And can they be consolidated?
So I have had 3 or 4 cases. I can think of 3, but I think there might have been a 4th, where the opposing party tried to consolidate the cases to save money and time. So there would only be one trial. And my client opposed it each time and succeeded.
What was the basis of not doing it?
The basis of not doing it is the superior court, the family court, can't have a jury. And therefore, my client, who's entitled to a jury trial for the civil case, can't have all his or her constitutional rights upheld when the family court is the trier of fact in a tort case. And so it worked every time. That said, I've heard decent arguments on the other side that a family court can have an advisory jury, can actually bring a jury in to hear the civil aspects of the case, because there is one superior court, and judges on the family bench are designated as family court judges, but that's an administrative distinction and not a constitutional one.
So do you ever, how often do you take it like all the way to trial? Do you typically settle first because it is sort of one of those things that's really good leverage?
Yeah, I've tried one in about 25 years of between my first one and my last one. One went to trial and we prevailed, but it's very rare, because especially when there are children, the perpetrator of domestic violence wants the domestic violence aspect of the case to go away very quickly. And so I can usually obtain proper compensation from my client in the form of a settlement or an augmented divorce settlement, rather than having to go all the way through a trial. Now, that said, on the other side of the coin, from a domestic violence case, there are business cases which require aspects of civil law to be brought in. For example, a breach of fiduciary duty, where under Arizona law, spouses owe each other fiduciary duties. And so a husband owes a wife a fiduciary duty, a wife owes a husband a fiduciary duty. That means when the wife opens a secret account in her own name and siphons off a little money every month, or a husband who's self-employed pockets a little bit of money every month, those things constitute breaches of fiduciary duty, and they support independent lawsuits. There are also cases where one spouse will own a community business. So let's say wife owns an interior decorating business, and husband notices that wife has been siphoning off money every single month, and the business is not doing well. Or husband owns a pool cleaning business and is not, let's say husband owns the pool cleaning business, and husband gives away his business's clients to his father, who also owns a pool cleaning business. In that circumstance, I'm going to come in and probably want to file a civil lawsuit and have a receiver appointed to take over the pool cleaning business to prevent husband from tanking it by giving everything to his father. And I'll probably bring his father into the lawsuit as well. And those are actually facts from a case I had a decade ago. And the husband did not roll over very easily. The husband claimed he owed his father a bunch of money. We did end up filing a separate lawsuit. We succeeded in having the court appoint a receiver, and the receiver, who was a pretty well-known business valuation expert in Arizona, made findings that the business received no value whatsoever for the customers that husband transferred to his father's business. And the father ended up having to give all the customers back.
Now, it's interesting because, you know, I don't know about you, but it seems like the family court is not as interested in ordering receivers take over a business. But I'm assuming then in civil court, they're probably, you know, that's probably a more common thing to happen. And is doing it through the civil court easier to get it?
It is. When you have a more experienced family court judge that maybe has served a rotation on civil, the family court judge is more likely to be willing to appoint a receiver. However, there is no family court rule of procedure that governs the appointment of a receiver. On the other hand, there is a civil rule with respect to appointment of a receiver. And so unless the family court is willing to stick its neck out, so to speak, and go above and beyond what the family court might think is its responsibility, a civil suit's going to be required. Likewise, I know we have some amendments to the family rules coming up. I think one of them permits a family court judge to appoint a guardian ad litem for a mentally or physically incapacitated spouse in the middle of a divorce. It used to be that some judges on the family court bench would be willing to appoint that guardian in the family case, and other judges would say, I can't do that, go to probate court and have that done there. And so it was very unpredictable. But family law intersects with every other area of law that I can think of.
Well, it is true. And it's really interesting. So maybe I can have you back to also do, you know, maybe the intersection of probate or wills and things like that, because those all sort of go together also.
They can, yes.
Now, I know I had asked you to talk about, can they be consolidated? And is being consolidated and tried together the same thing, or can those be different? Okay.
They can be different. I mean, the court can consolidate and then administratively bifurcate for purpose of trial only. I've never seen it happen, but it could happen. the family court could hear all aspects of the case not related to the civil controversy, and then appoint a jury for a separate jury trial on those issues. Frankly, that seems like a reasonable thing to do to me. But the way the court is headed these days, and the way the Court of Appeals is looking at family court and trying to limit the family court's responsibility to fix problems not properly within Title 25 of the Arizona Revised Statutes, I would probably advise against that.
Yeah, it's interesting because it does seem like we came so far this one way where they were trying to fix things, and now we're going actually way back to how it was before, where it's like, nope, let's just do the divorce, cut it up, and we're done. Yep. And so I'm not sure what's better. I part of me wants the courts to solve problems, and the other part of me says the court should get out of the problems. But so who knows? Maybe that's a whole nother podcast that we can have several people come in and debate it. That might be fun.
Absolutely. And the one thing everyone agrees on is the court should never become the problem.
True. And, yeah, that's true.
And there are times when the court becomes the problem.
Right. That happens, and the mental health professionals who are trying to help sometimes become the problem.
Absolutely.
So, okay, well, thank you so much for talking to us about the intersection of civil and family law today. It was great having you on the show today, and I look forward to having you on again if you're willing.
Absolutely.
Is there anything else you'd like to say? And by the way, this, like all podcasts, I will have Greg Davis's contact information down below and available in case you want to reach him and hire him or just consult with him and ask him some questions. He's very knowledgeable. He's been doing it for 30 years. So we will put all of his information and contact information down below.
Always happy to answer questions.
Okay.
Thank you for having me, Launi.
Thank you, Greg. It was good to have you here.